Good morning, everyone. My name is Olga Filipova. I am an associate professor in property at the department in the business school at the University of Auckland. And it's my pleasure to introduce Professor John Hopkins, a comparative public lawyer whose work sits at the intersection of disaster law, emergency management, administrative justice, and anti-corruption. John is director of the Lead Institute for Law, Emergencies and Disaster at the University of Canterbury. He also chairs IDEAL, International Disaster Emergency and Law Networks. He serves as the Pacific editor of the Yearbook of International Disaster Law, and last but not least is the co-lead of QuakeCoRE's disciplinary theme 3, which is Law Planning and Economics. So, as well as having a remarkably relevant set of acronyms around him, LEAD and IDEAL among them, John brings deep expertise in legal frameworks for natural hazards across Aotearoa New Zealand and the Pacific. So in this morning's presentation, John will explore some of the key legal lessons learned through research undertaken during the 15 years post-Canterbury earthquakes and asking, are we better prepared as a result? So please join me in welcoming John, and the stage is yours.
Kia ora koutou. Thanks for that kind introduction, Olga. I'll just do the traditional thing of sharing my screen. And can somebody give me a thumbs up if that has worked? Excellent. Yeah, so kia ora koutou. Now mai haere mai, and thank you very much for the kind introduction, far too kind introduction that Olga gave me. So as you heard, co-Dr. John Hopkins, 10A, I'm a law professor specializing. My methods are primarily comparative law. I'm a public lawyer, but these days I work primarily in practice in the fields, certainly in the applicable fields of disaster law. What I'm going to do today is, in some ways, following up from a presentation that we had from the Olga and Elan gave, my co-leads. On DT3 is to provide an overview of the lessons that we've learned in the past 15 years since the Canterbury quakes, since the 2011 quake. So the idea here was originally to be a team presentation so that we would provide some overviews of the different projects that have been undertaken and some of the learnings that lessons we've learned from them. However, it's a very busy time of year, and I've ended up being the last man standing because everybody else is busy. So you've got me. So I'm gonna give an overview. Some of these projects I've been involved in, some of them less so. So some of them I can give more detail on, some of them more of an overview. So hopefully you will forgive me if I'm not the expert on all the issues that I'm going to talk about. So I want to start by emphasizing the real fundamental connection there is between the Canterbury earthquake sequence and the study of law and disasters. Because without, excuse me, I've just realized my slides are not working. There we go. Without the events of the Canterbury earthquake sequence, our understanding of the connection between law and disasters it wouldn't be what it is today. I don't want to be too arrogant, but there's been a direct connection between what happened in those 2 years and the development of disaster law as a discipline. And the reason is because it was those events that caused it to become a focus of study and research at the University of Canterbury. Helped, it should be said, by QuakeCoRE's decision to bring in legal expertise into the QuakeCoRE family, particularly through Bob Kipp, who will be known to many of you, and I'll talk about his PhD later briefly, who actively engaged what was a developing idea around disaster law in UC, and then ourselves and others into the QuakeCoRE community. And that connection led to the development of LEAD, the Institute of Law, Emergencies and Disasters, which is the only research centre of its kind in the world. It also led to the establishment of a global international network that we support of disaster lawyers, because disaster law does exist, and the study of law and disasters exists across many countries and many people, but in small pockets around the globe. And that's allowed us to link them together. And of course, to make those connections, not only between legal academics and practitioners, but also between the disciplines without which the law around disasters would be irrelevant. Law is a discipline that relies upon other subjects for its raison d'etre. There's no point of having the law without the science or the evidence behind it. So I just want to emphasize that general connection. Without the Canterbury earthquakes, despite the tragic events and all the things that, of course, occurred for me personally and for many others, it had this direct link to the development of law and disasters as a discipline. Well, we've certainly come a long way since the early days of legal study in the aftermath of those tragic events. I have to say, I remember being met with a degree of amusement when I attended the first couple of disaster risk reduction or disaster risk management conferences, including the early QuakeCoRE annual meetings. As a lawyer, I'm not a lawyer, but a legal academic, and some confusion as to why I would be there. Admittedly, my first naive stumblings in the field were a little bit at fault. I used the term natural disasters in the title of my first paper on the field, and I've never forgiven I will gloss over that. It's an embarrassment my students like reminding me of. Anyway, but I think now we all accept, or most would accept, the integral importance of law to the disaster cycle. It's well accepted that, and it becomes obvious when we know that law is a sociological phenomenon, that it is that provides the means by which a society, any society, a tribe, a state, a family, it doesn't matter, any society manages its essential elements, what's often referred to as the law jobs. That's the purpose of law, and it can come in many forms. It can come written and social, informal, and through kin ties. It doesn't really matter. The methods, how they are done, is law. And then, as we know that disasters are not natural phenomenon, but social ones, the role of law, not just as a part of understanding disasters and our response to them, but it's actually at the centre of disaster studies, or should be at the centre of disaster studies, and specifically the study of seismic hazards and their impacts. In fact, at its worst, the cause of the disaster can, of course, be the legal framework itself, not the hazard. And that's something that I'll mention in a minute. So I think it's clear, and hopefully most people on this call would accept that the law is integral to our understanding of all aspects of the disaster cycle, both in seismic hazards and in other events. However, in this seminar, I want to draw a little bit of a distinction between law in the broad context I've just talked about, i.e. the means by which we manage our society, as a means of preventing or managing disasters effectively, and the concept of legal preparedness itself. And I'll explore that in a minute. But the idea of legal preparedness is that we need to prepare our legal systems for the crisis that will come, not just create them for business as usual. Now, this is not to say, of course, that law is not important in the other aspects of the disaster cycle. And in fact, much of the legal focus post Canterbury, and certainly a lot of my time and other members of the QuakeCoRE legal team in DT3 has been focused on prevention aspects. And much of the QuakeCoRE's funding has been on those prevention aspects. In particular, probably the example known to most of you, and the one you're most aware of, has been to focus on the regulations around building standards. And that has been a focus of the current and former members of our team, including Cameron Eade, who was one of the first in our group to study this. In fact, it could even be argued that the disaster that emerged from the events of 2010 and 2011 was caused as much by the failure of the regulatory system to regulate for known vulnerabilities. All these the vulnerabilities in the existing building stock in New Zealand were known, as I have discovered, and that the regulatory system did not ensure that the building stock that existed in what is in fact a drained swamp in a densely populated, seismically active zone, the Christchurch CBD, were not suitable for the purpose. If you take that view, you can see that the law, not the earthquake, caused the disaster. Now, in fact, I'm going to be talking about the earthquake-prone building, or the new attempts at managing this issue at the annual meeting. So I'm not going to talk any more about that now. I will bore you. I've got a second chance to bore you at the end of the year. What I'm going to do in this seminar, though, is I want to focus on the second element of the disaster cycle, just to go, if we use the traditional approach, and talk about that, the issue of preparedness. And briefly explore through a series of projects that we've undertaken through QuakeCoRE, this concept of not just preparedness, but legal preparedness. The idea that you need to prepare your legal system to manage with the crises that will come ahead. And I'm going to focus on particularly on research that's been undertaken with, as I said, with QuakeCoRE support and funding, and that has focused on the Christchurch Canterbury Earthquake sequence. But before I go to that, I want to talk a little bit about this concept of legal preparedness, which is one of those things that seems obvious, but until recently wasn't really recognised as a term in itself. This term and its development, if you start to use more generically, it doesn't have a direct link to the Canterbury earthquakes, but it does have a link to QuakeCoRE. The term was developed in the thesis of the PhD thesis of Holly Faulkner, who will be known to most of you. She was supported by RNC and QuakeCoRE, but her work was focusing on a different hazard. She was focusing on the Auckland volcanic field and volcanic hazards in general. She looked at what the legal tools were required to prepare a society to recover from an extreme level event, as I say, using volcanic hazard as the case study. How do we legally prepare for response and particularly recovery? What tools are required? And I think the analogy here is the toolbox, that when the event occurs, when the hazard occurs and you move to response and recovery, you need tools, both physical and legal, to undertake the things you want to achieve. What sort of tools do you want? She identified a number of examples. I won't go into the details here, but particularly planning for long-term evacuations. She pointed out looking at case studies overseas, and this is the same for many seismic events as for the volcanic hazard that she was looking at, that short-term evacuations become long-term permanent migration. So you need to have planning tools in place that will allow for effective long-term movement of individuals who are affected by the hazard. Health and safety issues, the role of cordons, evacuations, and many others, waste and the management of waste, and so on. So there's many things, I won't go through all of them, but many of these, of course, are relevant to seismic hazards. But the point I want to make here, the main point I want to make here is that, and one of her main points is that the legal system has to be in a position to respond to these needs at the moment of the event. Because the last thing you want to be doing is creating these legal tools in the midst of the hazard itself, the disaster itself, during the response phase. Which of course it's like a punchline to a bad joke. When do you not want to be creating legal tools to manage disasters in the middle of the disaster? It's not a funny joke either. And the maxim that rushed law is bad law exists for a reason. So that's the general idea. We've tended to now use this we've done a number of projects, I think, which have linked to this idea of legal preparedness, preparing not for BAU, but for the crisis that will come. And as with so many of the subdisciplines of disaster risk reduction and disaster risk management, which of course is quite a big universe of disciplines, the Canterbury earthquake sequence and its aftermath, unfortunately, has produced a rich mine of examples of the need to legally prepare, which in this case has allowed us to better understand what preparedness means as a legal concept and what we need to be thinking about, and what sort of elements we can actually, what sort of elements we need to be putting in place so we can prepare for future events, both seismic and other hazards. So I'm going to focus on the seismic today. So in the remainder of this seminar, I'm going to explore some of the examples that QuakeCoRE has funded across this idea of legal preparedness, or some of the things we've learned through those QuakeCoRE projects, particularly QuakeCoRE projects. So one of the first examples of the need to improve legal preparedness came from the work of Toni Collins. Unfortunately, can't be here today. She's an AI in QuakeCoRE, of course, and actually her work predated QuakeCoRE itself. And we didn't really see it in this concept of legal preparedness until now. Toni's early research explored the problems that existed around tenancy laws caused by businesses affected by the cordons. You've probably heard her speak on this before. The use of cordons, which of course has become standard practice with particularly seismic risk, but if you look at planning for future hazards, it's core to almost all hazard events. But it created a strange sort of Kafka-esque situation whereby commercial tenants who couldn't access buildings because of the cordons, but legally the buildings themselves remained usable. This then created a problem because though many of those commercial tenants were still liable for the rents, despite the fact they couldn't occupy the properties. In addition, many landlords were not in a position to stop charging rents given their own expense. There was also a problem about the ability of these often complex legal disputes. A number of these tenancy agreements were unusual, needed to be resolved. And the court lists, of course, were full, and courts are expensive, and many of the smaller businesses couldn't afford to utilise that process. There was no means also for unfair terms to be challenged, and so in many cases, commercial tenants would just would walk away, would continue to pay the rents, and then hope to bear the cost. This work and the realization that commercial tenancies need to be ready to cope with situations has led to changes in the standard commercial tenancy agreements, which are used in the majority of these agreements. That's not a state change; that was done by the Law Society. Another example, which I'll briefly talk on, but it's probably known by most people, is the management of course in property that has been, and we've got a number of ongoing research around how to manage what I've called hazard retreat. So again, related to land and property, but this time about when you move populations, how do you manage that? As the red zone in Christchurch has exposed, the legal tools around the movements of population are deeply flawed. They were clearly unfit for purpose. The red zoning scheme that was used to fill the legal gap was deeply unfair. It was inefficient, and in the final reckoning, as the Supreme Court has in effect ruled, it was ultra-vires. It's beyond powers. Red zoning in this sense, the Canterbury sense, will not happen again. But the need for natural hazard retreat hasn't gone away, and there is ongoing projects led by Toni and Holly looking at how future buyouts future management of retreats could be handled, which has come out to some extent from the NEMA exercise that took place in 2025 on the West Coast, which showed the fact that there was clearly going to be settlements that would need to be potentially moved, or populations potentially actively transferred, so with a compulsion, not a voluntary scheme. But the tools around that don't seem to exist. So there's an article on looking at the current legal tools about movements, which is in preparation. It's not been published yet, which that project will provide some more detail on. But the basic point is that the legal tools currently are not there for the sort of things it's clear, or it's suggested that we need to do come a major AF8 event. The issue, of course, then is what tools do we put in place? Moving to another aspect that has come out from our learnings from the Canterbury Earthquake sequence, the issue around health and safety. Moving away from the discussing of land and buildings, I'll move on to the issue about health and safety. So it's clear again from what we saw during the Canterbury Earthquake sequence, and this came out of a summer scholarship, that there's a major problem about the management of safety during response and recovery phases, the recovery phases of the disaster cycle. Research around that, which began as a short QuakeCoRE funded project, found, perhaps unsurprisingly, that although there are relatively clear health and safety requirements, not perfect, around emergency responders and associated workers, things become a lot more murky when one examines workers that are crucial to the recovery and the response, but not regarded as emergency responders. And this is particularly true of utility workers. As most of this audience will know, such workers, if they work for Lifelines utilities, which of course are legally defined under the CDIM Act, Lifelines utilities have a duty to ensure that their lifelines are working after the event. A legal duty up to a standard. The standard is a bit vague, but they do have a duty to provide those services. But of course, the utility workers are then potentially in environments which are not BAU. So they're if a emergency responder or an emergency worker, one would hope, would require under the Health and Safety Act that their Safety at Work Act, that their systems are in place to ensure that their safety is properly covered. However, for Lifelines utility workers, that is not necessarily the case. It becomes a lot less clear, because their BAU job is going to be very different potentially very different from the sort of thing that will go on in the earthquakes. And what in a response. And what that summer project found, was that although some utilities, notably Orion, seem to have developed relatively clear guidelines and actually managed the health and safety of their workers during this response and recovery phase pretty well, that wasn't necessarily the case for all entities. The framework, the current regulatory framework, was at best confusing and at worst dangerously silent, which of course could have real problems for those workers in the event of this issue. It's also another issue that arises, is that if workers are ordered to act under the Emergency Management Act, it's not clear that they would have the ability to refuse if the issue was dangerous. Anyway, so the bottom line is that the legal situation is confusing. So this summer project led to work that's recently completed. So Nellie, who was the student who took up the summer school project, she then took it up as a master's, looking at some global examples of where it could be learned from global examples of how to manage recovery workers, and particularly utility workers. And she focused eventually on the United States, where the US uses a legal terminology, uses different legal terminology, uses the concept of, it has an expansive concept of emergency worker, which includes all those utility workers, which in New Zealand would be seen outside the emergency worker definition. However, although prima facie that legal framework looks tempting, that you could expand the health and safety requirements and make that a core, certainly as a means of legally resolving the issue. Her deeper study found that in the US, the problem was implementation. Although in theory those legal principles exist, in practice the implementation around the safety of such workers is often left to is discretionary. I should say, linking back to Holly's piece, she raised this around the use of evacuations, that if you want to, the assumption around evacuation is you're going to use a lot of civilian drivers around buses, but those drivers, of course, are not employed usually to engage in cordon zones or dangerous areas. How do you manage that? Anyway, that was an aside. For a future discussion. Anyway, so much for some of the health and safety lessons and some of the land and property issues. And I've got a few minutes left, so let's turn a little bit to dispute resolution. So moving back to the recovery phase, one of the issues that has been a major lesson from the Canterbury earthquake sequence, and one where clearly the legal framework was not up to the task, was the dispute resolution mechanisms that existed. The field of dispute resolution. As Tony is often quoted as saying, she sees that this is a second disaster. The fact that we still have cases, disputes before the courts 15 years after the second earthquake is evidence in itself of a problem. DT3 has focused specifically on this aspect of legal preparedness, and Tony has led this, with myself and Natalie Baird also involved, also in partnership with the Natural Hazard Commission. And this has developed some clear lessons in this field too. The first point is the need to have systems in place that can manage the increase in disputes that will occur after a hazard. Now, that may seem utterly obvious, but we did not have that prior to Canterbury. Even now, I think it's questionable whether we would cope with a major event of a similar level. In the Canterbury context and in the New Zealand context, that revolves particularly around insurance. The issue, we would say, in the broader research is that there are other disputes, not just insurance. I mentioned tenancy already, but of course, in New Zealand, insurance is the focus. So this work part of this work has focused in particular on the Canterbury Earthquake Insurance Tribunal, and in particular, but it's part of a wider study of dispute resolution generally. Unfortunately, our student who was studying the wider project has withdrawn, so that element of the research is currently a bit in flux. But we can talk about some of the findings from our study of the Earthquake Insurance Tribunal. Now, one of the key, it's an interesting example, this, I think, because it's an example, I think, where good, deep academic research sometimes gets a little bit of a more nuanced understanding of how this body worked. The reason I say this is that if you ask people generally about the insurance tribunal, the Earthquake Insurance Tribunal, the institution, it's seen as having at best a mixed report card. It's seen as not achieving what it was set out to do. When you look at what the MPs that proposed it, and the government at the time that proposed it, they had high hopes that it would short circuit some of the reliance upon the courts and even up some of the imbalance between the insurance companies and the claimants. However, it's fair to say it failed to live up to this billing. And this was confirmed by the research project. We found a lot of criticism of the procedures that were introduced. It was supposed to be a low procedure, low cost in terms of procedures model, but that didn't happen. Much of the blame for that, I don't want to use the term, we don't use that in our work, but for the purposes of this, it fell on the legal profession. But I think the point we would say is that because the legal profession, of course, heavily involved in the tribunals, lawyers were involved, they brought their own court-based experience into the tribunal and turned it into a very adversarial and similar a lot of procedures operate like court. This led to delays and cost and so on. However, for all its faults, and we recognise that, we registered that in the work, there is also a lot of positives about the tribunal which I think have been missed. One of the things that we felt was that it did provide an important driver for insurance companies to settle. And that's something that we are concerned about. There's been a loss, a lesson that maybe hasn't been properly learned. We've seen the rolling out of alternative dispute resolutions post-event. Of course, we had the Greater Canterbury Claims Resolution Service that became the New Zealand Claims Resolution Service. But that we are interested to know. We haven't done work on this, but we'd see how this would work in the East Coast flooding events, because our concern is that the tribunal did act as a means to force the insurance company to think carefully about not accepting the mediation efforts of the Claims Resolution Service, because without the tribunal, the insurance company can say, well, we can go to court, and of course the individual doesn't want that option. Once you're in court, it's a very different kettle of fish. So I think one of the things that we would say about that is that there's more work needs to be done, because the insurance tribunal needs to be fit in that wider ADR world. But we're a little bit concerned that possibly the lesson has not been properly understood. So I know that I'm running out of time, so I'll skip on to another couple of examples. More broadly, in terms of the recovery, we've also seen the frameworks for community engagement. We've done work around this. There was a lot of attempts at community engagement during the recovery, and Suleiman Sarwari, our PhD, or my PhD student, alongside Sarah Bevan, studied how effective these community engagement methods were and looked at the legal frameworks in which they existed. I'll skip to the chase because I'm running out of time, but his lesson was that the framework that we have in New Zealand, which is largely court-based, it provides for a pretty low bar for community engagement. It's largely around consultation. And what he found was that in the main, although decision makers were permitted to have larger forms of engagement, I used one example there with share an idea, there were the possibility for community engagement, and he studied how that could occur. When it came down to it, most genuflected back to the very minimal legal requirements that have been developed by the courts around consultation, which don't meet the standards of community engagement that we would like to see. He used the Roe and Frewer, if you're knowledge of that, of the typology. So it certainly didn't hit those levels. And his point was that if we wanted, there were some examples of better community engagement, but they tended to exist only when it was embedded prior to the event. And after the event, so we saw outside Christchurch, in fact, outside the event, there was a tendency to default back to pretty minimal levels of community engagement, which are the legal requirements. And I think the argument there is if you want to see deeper community engagement, you actually have to mandate it. You have to build connections earlier, but you actually have to mandate it within the law. And then finally, just to finish up, because I think everybody's sick of me talking now, we'll have some questions. The big granddaddy of the legal preparedness question is, what do we do about governing recovery? I think it's fair to say, this is the million-dollar question, I think, that hangs over everything. It's fair to say that the methods that we used in the Canterbury Earthquake sequence are more deeply flawed. But one of the things, when I was thinking about what I was going to say in this presentation, I actually think, I'm not sure we've fully learned the lessons, both positive and negative, even though it's 15 years later, about the Canterbury, the SERA experience. We know the problems. I could mention some of them now, but they're probably known to most of you. But things like the fact it was a ministry, or it was accountable to the minister, meant it very difficult for communities to engage. You had to go through the ministry. The fact that the powers that it held were concerningly wide, and in effect emergency powers over long periods of time. It was also confusing how it worked, and strangely centralized, and that decisions often got jammed. But I'm not sure there's been a sort of overall legal understanding yet of what we can learn. But what we have done is in learning about, that's clear that's not the best method. Then we have looked to some other examples of recovery models. I should have said Robert Kipp's work on this was excellent, but it was a bit early, and he in effect studied why we got to where we got rather than the details of the system. But we have looked to alternative models, and one of the models that we have has been raised a lot of times, has been around the Australian Recovery Agency model. It's not really understood. Not much writing on this at all, which has surprised us. So Liana Villa, who's just concluding her PhD, has been looking her master's, looking at the Australian Queensland Recovery Authority, which has become the model, and to see the extent to which that something like that would that be the way of addressing some of the issues that have been raised about the different ad hoc systems we've used both in SERA and in the East Coast weather events. One of the interesting things about that is that the Australian example seems to have, because it's permanent, has pulled recovery back into the prevention and preparation phase. So the Reconstruction Authority in Queensland spends a lot of time has become a champion of preparation and mitigation and prevention efforts, which is a sort of interesting dynamic that I think is worth exploring. Suleiman also was employed as a postdoc to look at the Japanese model, where they attempt to embed BAU within their, they embed crisis management and emergency management within their BAU legislative framework. But I'll leave that for now. So that leads me, I'm out of time, so I will just stop. So I think to answer the question, I think we've learned that legal preparedness is central to our understanding of disaster management and disaster risk reduction, particularly in a seismic context. I've mentioned some of the ways in which we have that has become clear. But I think the other thing to point out is we've only scratched the surface, and many of the projects have been very quite specialised in particular aspects. There's a huge amount of work that needs to be done to try and grasp this subject and see how the legal frameworks can be better prepared. We attempt in our small team to push this forward. We look working forward to working with others and our international collaborators to take it forward in the future. But until I think we really get to grips with the legal preparedness that's required, I think the risk is that we, to paraphrase the words of Ian Kelman, have chosen the path of future legally triggered disasters. Ka kite anō, thank you for your time.